Good afternoon, everyone. I'm sure you've heard all about companies, so I'm here to talk to you about assurances that we have in place in Seychelles. And this assurance is under the SIFSA, the Seychelles International Financial Services Association. Seychelles has about 70 registered agents, corporate service providers, and SIFSA represent at least 40 members. And we work with the Financial Services Authority, where we bring your concerns. We like to work with the authority. We also follow changes that's happening worldwide, so we can sit with the authority to see how best we can incorporate anything in our law, and we represent you, really, our clients. Also in Seychelles, apart from the entities, we also provide a product which offers protection. Protection for your companies, your business, and this is through our trust and our foundation. So I will go briefly over what we have in our laws, our international trust laws, and after that, Dr. Fanny will go through the structuring. We like to think Seychelles is the preferred destination, of course. And our international trust provides for complete foreign participation. There is no tax. It provides for creditors' protection, good for estate planning, total privacy and confidentiality, and its fast registration. The confidentiality, we know in other jurisdictions, you now need to register your deed as well as the beneficiaries of a trust. In Seychelles, the register of the beneficiaries is kept with us as trustees, and it does remain confidential unless in the event that we need to disclose by a court order if there is an investigation, but very rare. And as we all know, for a trust to be valid, we need the certainties. We have to be sure that there is the intention, and the intention is actually to part from the ownership of your assets, the subject matter, and the object being the beneficiaries. The trust has to be set for the benefit of the beneficiaries, otherwise there's no object. How would you use trust and companies? A trust can be shareholder of your company. This is one way to protect your assets, especially in risky business. Sorry, I'm going to move a bit forward, but you will have this slide in your bag for you to go over. And we're available for questions as well after. A family trust, of course, ensures peace and business continuity after death. In the first place, you have set up a trust, most probably, so it goes on to the next generation of family. It provides for a smooth transition to the next generation. It also avoids family dispute. And unlike a will, the properties are transferred while you're alive, and the arrangements will continue after death. As I mentioned, it's good protection for your business, as it would avoid large losses and personal liabilities. It's a good vehicle for premarital assets in cases of divorce. And the good thing about our trust in Seychelles, there's reserved powers. So the settler, the person who set up the trust, has powers to be a beneficiary as well, which means you will retain control. You may retain control of the trust by being a director on the company. You may also be beneficiary, but not the sole beneficiary of the trust. And also there's protector's powers. Okay, I'm going to miss a bit of all the shams. For the trust not to work, it may be struck down by a court if it is a sham trust. And a sham trust is a trust that's been set up as a pretense that it is a trust where in reality it is not. There are some very good case laws which is worth looking at to avoid your trust being a sham. For example, you cannot set up a trust for the purpose of to put it in a safe place for a rainy day. It doesn't work. It may be challenged in court. And if it is challenged, the assets returns to the settler of the trust, which means you are now open for your creditors to come after you. The most famous trust case law, which I will go over, was Rahman versus Chase Bank. And Chase Bank was the trustee. Mr. Rahman, he used his trust as if it was his personal account. After his death, his wife and his son challenged the trust. Very interesting and worth looking into. So to avoid a sham trust really is to release more powers to the trustees or the protector, to have clear letter of wishes. The letter of wishes is an additional document which you would have with your deed of trust, where simply it's laying out your wishes, what you want. And the trustee will be guided by your letter of wishes. So the settler will have peace of mind to know that his wishes are being met. And also to avoid powers of revocation. It's always good to have an unrevocable trust. If there are the revocation in the deed, it is easy for the court to revoke the trust. It's more difficult if you don't have this power. And the consequences, as I mentioned again, it returns to the settler. Creditors will come after you, and the trustees will have no power. Also, the other danger is any distribution which may have been made to beneficiaries may be claimed back. Nevertheless, beneficiaries cannot be responsible, innocent parties cannot be responsible for a shamming settler. We also have a private foundation in Seychelles, and it's a separate legal entity. It's a hybrid between a company and a trust, and the assets are held under the name of the foundation, and there's more control over the assets compared to a trust. So the advantages of having a foundation are its asset protection. Assets cannot be used to satisfy the debt of the founder of the foundation. And the creditors has 2 years to make any claim. If after the 2 years no claim has been made, they cannot go after anything of the founder or the foundation. Arbitration. The foundation charter may provide that any dispute be resolved by arbitration. And the capital requirement for foundation is $1. There's no public records for the total capital amount that would go into the foundation thereafter. So the only information that would be available was the $1 transfer. So the confidentiality kicks in here. Privacy, the beneficiaries are not publicly known. The foundation can be shareholder of underlying companies. There's no taxation. Transfer, donation of assets to the foundation is not subject to taxes. And income generated by the assets are not subject to tax. A foundation is recognized in both common and civil law jurisdiction. It's a very good product. Control. The founder has a lot of control. They can make amendment to the charter. They can appoint and they can remove their councillors. They can restrict beneficiaries' rights. They can add and exclude beneficiaries. They can also, the founder can also be a councillor, and he may transfer his rights to third parties. And a protector may be appointed by the founder, or it may be appointed by the council. And the protector has authority to remove approved action by the council and authority to remove the councillor from the council. Dr. Fanny will go through the structure, and this will include trust and foundation as well. Thank you very much.